Now we're moving into the patent in itself and what that really is. So the patent is, in its essence, nothing more than a deal between the state and the business owner. The deal gives the business owner 20 years exclusive right on the market at which the state controls. And the states, in return for this monopoly, gets a full description of the invention. And that is what it's. Most of the text in a patent is really this description. So it is obvious why the business owner would like to have 20 years monopoly for his new product, which has been patented. It might not be that obvious why the state would be interested in signing such a deal. But if you think about it, you realize that this full description of the invention gives the state a possibility to repeat the invention, and for anyone in the state to repeat the invention after this monopoly has run out, after those 20 years have passed. So that is the deal. And the patent system is pretty old now. I don't know, more than 100 years at least. So if it wasn't a good deal, we wouldn't have a patent system, because somehow it seems to benefit, seems to be desirable for both parties. Well, over here at the right side, you'll see the business owner. He's standing on a pretty good foundation of promising data and maybe a patent or a patent suit to be, and hopefully with a solid business plan. So he's looking over here at this bridge, and he desires to pass that bridge as soon as possible to get over here to on the left side to find himself in a position where he has a lucrative new product, and he could get the fruits from that in the form of the economic benefit that would give the business owner. And hopefully this new product is also beneficial for the rest of us, not only for the business owner and the business owner's profit. The foundation at this left-hand side, at the other side of the bridge, is founded by an enforceable, that the business owner might use the state's legal system to fight off his competitors. And the bridge is to a large extent held by this business deal. That is a really strong thing. You want this bridge to be strong before you take the first step over it. And the possibility to fight off these sharks here, which is representing the competitors on this journey, is they swim here down in the what I call valley of death for the business, that is. They are accompanied by another lurking creature down here also, which is written in this way to symbolize your own bias as a business owner. You have definitely an own bias. You tend to have really clear glasses when you want to see the beneficial parts of your business idea. And all issues and potential problems that you might have with your business and going forward with your business idea, it tends to be seen through very dim lenses. You're almost blind to. Some people are almost blind to them. You don't want to see the bad things. Not at this point in time when it's really exciting. We're going to cross this bridge and you're going to get over to the other side and make a new medicine, make a new product. And the economic incentive should not be forgotten at this point in time either. So let's let's break out a little bit and discuss this working creature, which is your own bias. Within the business domain, the best weapon to fight off this lurking creature could be formulated as kill your darlings as soon as you have good reason to. That means if you have the possibility to conduct an experiment, ask difficult questions already at an early point, which answers or results would give you solid proof that your business idea cannot hold it to the outside. It's like you're going to cross the Atlantic with a boat. If you could identify a half-meter diameter hole in the bottom of that boat, you'll know that you will not cross the Atlantic. So why not look at the bottom of the boat already from the beginning before you continue your journey? And when you think about it as a researcher or a scientist, it is nothing more than a development of the old traditional scientific method. The scientific method, as we all know, is of course to formulate a hypothesis, and then you do everything you can to falsify it. And all your peers and colleagues would do the same. And if you're able to falsify it, or if someone else is able to falsify it, you'll thank them for it, because that gives you an opportunity to change track immediately, formulate a new hypothesis, and do it all over again. And that is how scientific progress develops over time. And that is the best method we have so far to fight off our own biases when we do things. So, as I said, it's just a new formulation of the same thing within a business setting instead of in a research setting. Now we'll dive into the details of the patent itself. But first we have to put it on the map also. You have, most probably all of you have heard the IP and IPR terms. IP is immaterial property, stands for immaterial property. That is property which is not physical, but still a property, something that has got value. IPR stands for immaterial property rights, and that is the legal rights you have to this non-physical property, which, as I said before, could be you could use the state's legal system to fight your rights there. So, patent is the most important and the strongest and the most desirable immaterial property that you could hold, or IPR, material property rights that you can hold, because the patent is constituted and dependent on a certain specific technical solution. If you want to go around the patent, if a competitor wants to go around the patent and come into the same business, they would have to define a new technical solution. If someone would like to compete with Pfizer for a new corona vaccine, well, they would have to find a new technical solution. You would have to, come up with a new sequence that might not be as good as the Pfizer's original sequence and so forth. So that is the strongest. If you think about design is just the shape of the bottle, like the Coca-Cola bottle. You could easily change the shape and you could still, have a container with Coca-Cola in it. So design is, of course, very, very desirable for an already established company. The same is true for trademarks or slogans or words that you could protect. Copyright, that is also text, like in books or in computer code or in music. And then we have the last one, trade secrets. If you're interested in design, trademarks, copyrights, and maybe also trade secrets, then you could, and I would recommend you to look at PRV's, the Swedish Patent Authority's homepage, and they discuss briefly all of these different IPRs. But we are focusing on the patent today. So in order for the state to sign the deal with you, the patent deal, they are obligated, they are really obligated to sign this deal if you can fulfill a few prerequisites for this. And the first is, of course, and which is of utmost importance for the states, that you provide a full description, which allows the skilled person to repeat the invention. The skilled person is, in this case, defined as someone who is familiar within the particular field. It could be virology, or it could be chemistry, or it could be whatever the patent is about. It also has to contain a precise, clear, and legally correct set of claims, or one claim is really enough. And that is to razor sharply define exactly what this invention is about, to be able to determine if someone is infringing on it or if someone is without it, so that you can use the legal system to fight them. It has to be supported by examples. What you claim has to be supported by examples, or at least an unfalsifiable sound reasoning. And when it comes to the reasoning, it could be good to know that it is up to the patent examiner to prove you wrong. If you have a sound reasoning why this would work, and the patent examiner won't believe it, then it's up to the patent examiner to prove you wrong. The burden of proof is on the patent examiner. And you most probably have heard that a new invention, patentable invention, has to be novel, that it has not the exact description, or what you claim must not have been published anywhere else in the patent literature, or in the scientific literature, or not even in the Swedish magazine Kvällsposten, because then it belongs to the prior art and it is not novel. It was known from before, so you cannot be granted a patent. Also, it has to be inventive. It is roughly equivalent with non-obvious. If something is obvious, it does not comprise an inventive step. So it has to comprise some inventive step, or some smart and non-obvious way of how you combine different things, and you end up with a result which is very positive and but non-expected. That is what you're looking for, and very often you will have to, little subjective, and you would have to make a case and in correspondence with the patent examiner to explain to the patent examiner why this is really non-obvious. Am I being misled by the literature in another direction so that I wouldn't arrive at the claim of my patent, and so forth? Subjective. And also it has to be industrially applicable. And of course, the business holder is trying to do business within industry. So I have never seen any case where a patent application has failed because of not being industrially applicable. You have a few other also additional prerequisites which you might not be that familiar with, but could be good to know. So in Europe, at least, or at most places in the world, I think in the US it wasn't like this before, but you may not claim an invasive method in itself, for instance, a surgical method. And that has got more or less to do with moral and ethical reasons, because you don't want anyone stumbling into the, when the surgeon is trying to, remove the appendix via this new method where you remove it from the backside instead of from the front side, and stop it. Here you're doing patent infringement. So please put down your scalpel and stop this surgical procedure. That would not be ethical. At least I don't think it would be very ethical to do that. it may not be a discovery scientific theory or mathematical method in itself, like the scientific discovery that hemoglobin is the transport protein of oxygen in the blood. That's a scientific discovery. But you could easily turn it into an invention if you take the heme part of the hemoglobin and address it with another protein, and you've got a synthetic blood. That is definitely patentable. Might not be a computer program either, and that I want to point out that because very often I get questions if you could patent computer programs. You cannot do that because they belong rather to the area of copyright. You could do some tricks and attach some physical things to it, and a USB stick, for instance, with computer program would be patentable in itself because it's connected to something physical. But it's tricky with computer programs. Also, it might not be contrary to the public order or morality, like a letter bomb. Never mind how novel it is and how ingenious it is and non-obvious to construct. You could not get a patent because it's not ethical to develop letter bombs to kill people with. And also it has to be it may not be non-falsifiable. That it has to be like in the scientific method that your hypothesis is a good hypothesis only if it's providing some way so that it could be falsified. The same is true with patents, and by having this prerequisite, you fight off stupid things like the claim that you have invented the perpetual mobile machine that would run forever. So the patent system is we said that the patent is a deal between the business owner and the state. Well, the state could be like Sweden here, which is a national patent system. So from the beginning, you had to file a patent application in each state where you wanted a patent. You had to sign separate deals with different states. But after that is really cumbersome and expensive and difficult to carry out and really of no one's interest. So eventually, lots of states, most of the states really has agreed that it's okay if one of the states, the patent authorities in one of the states take a look at the patent application to determine if it's patentable or not, and the rest of us will agree that we will grant a patent if that state finds it to be good. So that's the PCT, the international patent system, I would say. Everybody uses it all the time because it enables you to push costs in the future, and I will discuss that more. And then you have something in between, like the European patent system, and also you shouldn't confuse the European patent system with the European Union. For instance, you would notice here that Great Britain, which has done a Brexit, and also Norway is included in the European patent system. So they overlap a great deal, but they are not equivalent. And you have heard a lot of these terms also, the priority date of the patent application and so forth. What you'll see here is I would say, the best strategy. I have never seen any better strategy myself, at least, if you want to push costs, but you still want to keep the priority date, which is your date that you definitely want to have all the time. What you do there is that you file a patent application with one of the states belonging to this PCT agreement that we looked at on the last slide. You'll file a national patent application with any of these states, let's say Sweden. And at time equals 0, you'll then get a priority date. When you have this priority date in hand, you could claim that you're the first one, that this is your invention. So it's very important to get a priority date. Anyone who comes after you and filing a patent application, which happens to be the same as yours, they're not going to get the right. You're going to get the right because your priority date was before in time as compared to theirs. So the priority date is extremely important. And then there is about the time lag of about 6 months from the priority date. This is when you get the first search report from the patent authority, in this case, the Swedish PRV. What this will provide you with are really clear glasses, so that you have an independent search report from an independent authority that would give you truth. You might have thought that this was patentable and really great things, but you'll get an independent report, and that should be a strong guide to determine if you should continue with this project, this business project, or not. Very important. First search report that will give you an independent view. And then we have the 12-month deadline to get into the PCT, this agreement. This agreement includes an agreement that up to 12 months after the priority date, you are allowed to file the same application as a PCT application and you'll keep your original priority date. So if you lose these 12 months, you've lost your priority date really on the international market, at least. And then we have an 18 months date from the priority date, which is very important. This is the date when your original patent application will be published, so that your competitors will be able to read what you're up to in detail. Because remember, the patent had to contain a comprehensive and detailed description of your invention. That will be given to your competitors at the 18th month after your priority date. And then we have 30 or 31 months after the priority date is when you have to decide which countries you're going to have local protection. Is this medicine something that the Danes would like? Well, probably. Then I should make sure that I see to that the patent is also going to be validated in Denmark. And this is, of course, very costly. So, but at this point in time, you would also probably know if you have a business or if you do not have a business. But 30 or 31 months after the priority date, this is when you have to have really a good sense of where your market will be. And you probably need a lot of money to protect as much as you like to. Now, let's move back to the bridge again. The business owner in this case happens to be a researcher from the Cancer Research Laboratories, having made a tremendous discovery and thinking about doing some business out of it. And he's looking out here on the other side. Hope this bridge holds. The situation that you would face at this point in time, you could be sure that you will be surrounded by other people that are very interested in the development of your business. Some of these people would be crucial for you to be able to cross the bridge. You wouldn't need them. You wouldn't make it over the bridge unless you got their help. Some of them would be a negative contribution. I would say they would more or less cost you money, and they wouldn't provide anything of use for you to be able to cross this bridge. And the question is then, how do you determine who is who and who are you going to partner with, and who are you going to say thank you but no thank you? So, well, my recommendation would be to gain further insight into the new and yet unfamiliar field with this business. And I can't speak for the business, but I've so far tried to give you some insight into how the patent works, because there are people that would like to help you with patents also at this point in time. And again, never forget scientific method, kill your darlings. Apply that test already when you're standing there and and that's a good point in time to carry out really serious tests in accordance to this, because if it's not going to be, you don't want to have to back off. Maybe you've come so far out on the bridge that it would hurt you economically really bad. So better never take the first step if you can make sure that you're not going to cross the bridge. So now I'm going to give you some insights that you might not have had before. And the first insight is that you as scientists, you are very familiar with putting together scientific manuscripts where you sum up your recent scientific discoveries. If you look at it really, I'll show you this. This manuscript is more or less an already written, although maybe a little rough, patent application. So at the point in time when I wanted to find a suitable example to illustrate this, I thought, what am I going to do, and how am I going to find a suitable paper? So I thought that I'll just Google the first one who showed interest in attending this seminar, and I found that the same person happened to be a principal investigator, and that this this paper here was really good example. Reverse inhibits colon carcinoma cell migration by targeting JNK1. So, okay, we're into something against colon carcinoma. That's a great thing. Really important scientific discovery, and also probably might be patentable. So if you look at this manuscript before you have sent it off for publication even, you'll realize that it contains the full description, allowing the skilled person to repeat the invention. The skilled person would even be able to look at the in vitro data which this paper contains and come up with a proper human dose in an oral tablet, and at least roughly, based on models already, what is the difference between the metabolism in rats and mice and humans. So, full description allowing the skilled person to repeat the invention. Actually have a good idea about what the human dose would be. What you lack is a precise, clear, and legally correct claim defining the invention. I'll get back to that. You have lots of examples which supports this invention. You have lots of in vivo data and all in vitro data, and also you have some in vivo data when I brushed through this publication. Is it novel? Well, we have to assume that the scientist who is putting together this paper would know if it's novel or not. If someone has found that reversing might inhibit colon carcinoma or not. If someone already had published it, it would probably be much more difficult to publish this paper. Is it inventive? That's a tricky one, but you could do some reasoning. Is it non-obvious, considering what is known about reversing from before? Is it known what kind of molecular targets it hits and inhibits? And is there a reason to assume that these molecular targets also would be associated with colon carcinoma or not? And you would have to decide yourself. But let's say that you find out that it is not obvious that reversing would be good for this colon carcinoma. Is it industrially applicable? You bet. If this holds true, it's definitely industrially applicable. So the only thing you really would have to complete this manuscript with before sending it in as a patent application would be one claim. These 10 words would be all that you would have to end the manuscript with and send it in as a patent application. Reversing for use in the treatment of colorectal cancer. That's it. It's a precise, clear, and legally correct claim. Maybe it's not perfectly legally correct, but the patent examiner would tell you how to fix it, just like a reviewer would tell you how to fix your paper to get it published. And if you're if you're into it, and if you would like to expand this patent claim into a set of claims, even like a set of claims of 2, it might look something like this. You might take the reversing molecule and expand it a little bit, like remove the cyclohexyl group here and make a generic group here, and try to claim all these molecules that would fit in within this generic formula, because maybe one of them would be even better than reversing in fighting this colon carcinoma. But then of course, you wouldn't have backup in your manuscript, because you have only investigated reversing in this case. So you would have to define a subclaim which would be a fallback position, and you would make sure that this fallback position has full coverage in your manuscript. Then, having this at hand, it would take no more than half an hour to send it in as a national patent application to get a priority date, like on PRV's online form. This is the first page of that, what it looks like. Title of the invention, maybe novel treatment of colorectal cancer, and your reference to the application, maybe doing it myself, 1 or 2 or 3, and so forth as you progress. And the cost would be, this form would end with the payments, and the cost would be 3,000 crowns, unless you have more than 10 claims, because then it would cost 500 crowns more or something per claim. And then after about 6 months, you'll get the search report. And as I said, this is the report that you should pay attention to. Is this really something that I could do business around or not? Might look something like this. PRV cannot grant you a patent since, and then you get hints on what you could do. They admit that it's novel. All the claims, in this case 1 to 6, they happen to be novel. Great, that's the biggest hurdle. Is it novel? Yes, PRV admits that it's novel. They do not think, however, that it has got an inventive step. I could tell you that after some reasoning with PRV explaining why it is actually non-obvious, this particular patent application is now a granted Swedish patent. So, how do you find information to find out if your invention is novel or not, and if it's non-obvious or not? Well, you would be familiar with the Google search engine. That's a good starting point to start to look. And if you want to be more sophisticated, I would recommend Stasnet. That's a database which contains all published patent applications from the beginning of time, more or less. And it also allows you to do really Boolean algebra, a kind of direct searches with and or operators to fine-tune your searches to get the hits that you really would like. It contains a huge amount of information, and I recommend it to fiddle around with this and get to learn. So, in summary, the patent is a win-win deal between the inventor and the state. We have gone through the prerequisites. Basically, it has to be novel and non-obvious, and also has to contain a full description of the invention that could be repeated by the skilled person. Again, I cannot put enough emphasis on this, because this is, if I had put more emphasis on this, I would probably have saved at least 5 years of my life, where I could have done other things instead of moving into blind alleys. So beware of your own tendency to fall in love with the projects. Apply the scientific method, apply the kill your darlings trick to fight this tendency off. And as you have seen, or I hope that I have illustrated, that do it yourself is a good way to begin. It's not as difficult as others might want you to think, or as you might think yourself. So I hope that I have provided you with some insight and maybe put you in a situation where you're a little bit more confident that you could actually do this yourself. And by that, I would like to, again, answer any questions you might have to the best of my ability. I'm leaving this slide on to give you my email and telephone number in case you would like to discuss something that has got to do with this afterwards.